The doctrine of frustration provides that if, after a contract is entered into, events occur without the fault of either party which make it impossible physically or commercially, if it loses its commercial purpose, to perform the contract, then it is automatically terminated, so as to relieve both parties of their future obligations under it. Whether or not a contract will be regarded as frustrated depends upon the obligations created by the contract and the circumstances that occur. It is key to remember that frustration is exceptional and provides one of a variety of ways by which contractual obligations end. Where a contract is discharged by frustration, this occurs automatically by operation of law. The courts decide when a contract has been frustrated, and if they decide that it has, then all future obligations cease. The consequences of this are dealt with both by common law and statute. The Law Reform Frustrated Contracts Act of 1943. Key cases explaining the requirements for frustration include Taylor v. Caldwell from 1863 and Davis Contractors v. Farnham Urban District Council from 1956. We will start our overview of this area of the law by looking at some of these key cases. In Taylor v. Caldwell from 1863, the courts regarded most contractual obligations as absolute. As the promisor promised to perform, come what may, he could not rely upon supervening events, other than breach of contract by the other party, as an excuse for non-performance. An example of this of the rules of contract before the evolution of the doctrine of frustration that Lord Justice Bingham mentioned is Paradine v. Jane from 1647. In that case, a farm tenant was excluded from his farm for 2 years by enemies of the king and claimed that he was not liable for the rent for the period he was dispossessed. It was held that he was liable nonetheless, regardless, as he had assumed the obligation. In situations where there is a change in circumstances not attributable to the fault of either party, such that performance of the contract would become something radically different from what the parties originally intended, justice requires that the courts should treat the contract as having come to an end. See National Carriers v. Panalpina from 1981. It is quite possible for the parties themselves to make provision in the contract for what is to happen should the performance of the agreement become impossible or radically different as a result of some subsequent event for which neither of them is to blame. This is common in commercial contracts, which frequently use what are known as force majeure clauses. Where there is a clause of this type which covers the situation which has occurred, then the courts will give effect to it. The issue will no longer be one of frustration, as contractual provision will take precedence. We only talk of frustration when the event is not in fact addressed by the agreement between the parties. Be careful with this distinction, as in most jurisdictions material on force majeure and frustration will be distinct. We now move on to discuss more closely the nature of possible frustrating events. Frustrating events. Courts have consistently indicated that the contract will be frustrated only where there is a complete change between what was undertaken in the contract and the circumstances in which it is called upon to be performed. See, for example, CTI Group versus Transclear from 2008. The following types of frustrating events have been noted in the case law: distraction of the subject matter, personal incapacity, non-occurrence of an event or failure of the commercial purpose, effects of war and other government action, and we will now look at them in turn. First, we start with distraction of the subject matter. The most obvious example of this is the case of Taylor and Caldwell from 1863. Judge Blackburn reasoned that the rule of absolute liability set forth in Paradine and Jane only applied to positive, definitive contracts, not to those in which there was an express or implied condition underlying the contract. Blackburn further reasoned that the continued existence of the music hall in Surrey Gardens was an implied condition essential for the fulfillment of the contract. The destruction of the music hall was the fault of neither party and rendered the performance of the contract by either party impossible. Blackburn cited the Civil Code of France and Roman law for the proposition that when the existence of a particular thing is essential to the contract, and the thing is destroyed by no fault of the parties selling it, the parties are freed from the obligation to deliver the thing. He further analogized to a situation in which a contract requiring personal performance is made and the party to perform dies. The party's executors are not held liable under the common law of England. Blackburn thus held that both parties were excused from their obligations under the contract. Personal incapacity. Another clear case of frustration will be where both parties have agreed that the contract is to be carried out by a particular individual and that individual dies or is too ill to perform. See Condor v. Baron Knights from 1996. Non-occurrence of an event. A number of cases concerned with the cancelled coronation of King Edward VII in 1903 illustrate this category. In Krell v. Henry in 1903 and Herne Bay Steamboat v. Hatton from 1904, the core of these cases showed the idea that if the commercial purpose of the contract has failed completely, then the contract should be considered frustrated. Let's look at them in a bit more detail. In Krell v. Henry, 1903, the defendant agreed to hire from the plaintiff a flat in Pall Mall June 26 and 27, on which days it had been announced that the coronation proceedings would take place and pass along Pall Mall. The coronation of Edward VII and Alexandra of Denmark as King and Queen took place at Westminster Abbey in London on the 9th of August 1902. Originally scheduled for 26th of June of that year, the ceremony had been postponed at very short notice because the king had been taken ill and required immediate surgery. The contract contained no express reference to the coronation processions or to any other purpose for which the flat was taken. A deposit paid when the contract was entered into. As the processions did not take place on the days originally fixed, the defendant declined to pay the balance of the agreed rent. The court held, from necessary inferences drawn from surrounding circumstances, recognized by both contracting parties, that the taking place of the processions on the days originally fixed along the proclaimed route was regarded by both contracting parties as the foundation of the contract. That the words imposing on the defendant the obligation to accept and pay for the use of the flat for the days named, though general and unconditional, were not used in reference to the possibility of the particular contingency which afterwards happened, and consequently that the plaintiff was not entitled to recover the balance of the rent fixed by the contract. In other words, therefore, the postponement of the coronation meant that the contract had been frustrated and the parties were obligation of further performance. Not all cases arising from these facts, however, led to the same conclusion. In Herne Bay Steamboat v. Hatton from 1903, we have the same set of events. In consequence of a public announcement of an intended Royal Naval Review at Spithead on June 28, 1902, an agreement in writing was entered into between the plaintiffs and the defendant that the plaintiff's steamship, Cynthia, would be at the disposal of the defendant on June 28 to take passengers from Herne Bay for the purpose of viewing the Naval Review and for the day's cruise around the fleet, or June 29 for similar purposes. Price payable before ship leaves Herne Bay. On the signing of the agreement, the defendant paid a deposit. On June 25th, the review was officially cancelled, whereupon the plaintiffs wired to the defendant for instructions stating that the ship was ready to start and also requesting payment for the balance. Receiving no reply, the plaintiffs on June 28 and 29 used the ship for their own purposes, thereby making a profit. On June 29, the defendant repudiated the contract. During the 2 days in question, the fleet remained anchored at Spithead. In an action by the plaintiffs to recover the balance less the profits made by the use of the ship during the 2 days, it was held that the plaintiffs were entitled to recover because the venture was the defendant's, the risk being his alone. and the happening of the naval review was not the sole basis of the contract, so there had not been a total failure of consideration nor a total destruction of the subject matter of the contract. Limitations. There are two principal limitations on the doctrine of frustration. The first is where the frustrating event has been foreseen and provided for in the contract. The second is where the alleged frustrating event has been self-induced by one of the parties. In the commercial area, force majeure and similar clauses may well replace the common law and statutory rules on frustration. The courts have tended to narrowly interpret such clauses. See Jackson versus Union Marine Insurance from 1874. First, we will deal with the issue of foreseeability. The case of Ocean Trump Tankers, the Eugenia, from 1964, illustrates these key limitations well. First of all, we can consider how foreseeable does the event need to be to prevent frustration. First, if there is contractual provision for this event, then we have no frustration. Secondly, if the event is not covered, how different is it from the situations provided? Lord Denning argued that the contract would be frustrated if it were unjust to hold the parties to the bargain. We can therefore inquire if the contract has become something radically different. It becomes therefore necessary to determine whether a party assumed the risk of the occurrence of the event that lies at the root of the inability to perform the contract. Further, if performance is rendered merely more expensive, inconvenient, or difficult, the contract will not be frustrated as a result. We now move on to the issue of self-inducement of the frustrating event. Another important element of the doctrine of frustration is that the alleged frustrating event must not be attributable to the fault of either party. If it is, then the likelihood is that the party at fault will be in breach of contract, and the doctrine of frustration will have no application. The courts have interpreted the concept of fault widely in this context. In fact, it may be more accurate to say that whenever the alleged frustrating event is attributable to the actions of one of the parties, whether these involved fault or not, then the doctrine of frustration will not apply. See Maritime National Fish versus Ocean Trawlers from 1935. Effects of frustration. One common law rule which operates even where the act is also applicable is that the frustrating event terminates the contract automatically, without any need for action by either party. It follows that any attempt to affirm the contract following frustration will be ineffective. See the case of Hirji versus Chongyang Steamship from 1926. As to the distribution of losses following frustration, the common law started from the position that all future obligations were discharged post the frustrating event, but that obligations incurred prior to the event survived. Where the loss fell would therefore depend entirely on what the contract said about when payment was to be made or when work was to be done. See Chandler versus Webster from 1904 and Fibroza Spolka from 1943. The inflexibility of the common law rules, even following the slight modification provided by the Fibroza case, led to demand for reform. This occurred in the shape of the Law Reform Frustrated Contracts Act of 1943. Two main provisions in the 1943 Act are Section 1, subsection 2, which deals with money paid or payable prior to the frustrating event, and Section 1, subsection 3, which deals with benefits conferred prior to that event. Section 1.2 provides that where money was paid or payable prior to the frustrating event, it should be returned if paid, or should cease to be payable if not paid but owing. Unlike the common law, this is not dependent on there being a total failure of consideration. A total failure of consideration would entitle a claimant to seek a restitutionary remedy. Wincap v. Hughes, 1871, is authority for the proposition that the claimant may seek a restitutionary remedy by saying that the basis upon which he conferred the benefit has failed entirely. in this case because of the defendant's breach of contract. If any part of the contract is performed, or if the claimant has received any part of the consideration, the restitutionary claim is barred. See Tinsley v. Milligan from 1993 and Lipkin-Gorman v. Carpnail from 1992. Section 1.2 of the 1943 Act provides that if expense incurred towards the performance of the contract, some of the money paid or payable may be returned or recovered to the extent that a court considers it just in all the circumstances. Section 1.3 deals with a situation where a party has received a benefit other than money paid prior to the point at which the contract was frustrated. In that situation, the section allows that the party can recover from the other such sum as the court considers just, having regard to all the circumstances of the case.